Hi, everybody. My name is Kirk Tousaw. I'm here to talk about mandatory minimum sentencing and your medical cannabis business, whether it be a dispensary or producer. First, I'd like to thank our host this evening, Mark Emery's Cannabis Culture Headquarters, BCMP Vapor Lounge, Jody Emery, and everybody here graciously allowed us to use this space. Mark, of course, and Jody, victims of the U.S. drug war, which is insinuating its tentacles here into Canada in the guise of these mandatory minimum sentences. So I'd certainly encourage everybody here tonight to, if you don't already know the story of Mark Emery, please check out freemark.ca and get involved in the fight to bring him home. It's really, I'm pleased, I'm humbled, I'm gratified to see so many people in this room. It wasn't that long ago that I almost knew everybody that worked at a medical cannabis dispensary in Vancouver, and this room would have been full of familiar faces, and we sort of all knew each other. It was a very small community. And now, something on the order of 7 years later, there's so many different people involved, so many brave people willing to put their liberty at risk to try to help others in need of cannabis, a plant that brings so much good and healing to so many people's lives. And I think it's also a testament to the development of the industry here, particularly in British Columbia, because that's what I'm familiar with, but the medical cannabis industry and the pioneers that began this many, many years ago, began this journey. People, some of whom are represented in this room, people like Hilary Black and Ted Smith, Philippe Lucas, Matt Barron, and others who really started to blaze a trail that many other people are following. And I think, this medical cannabis industry has grown in a really responsible way, particularly here in Vancouver, on Vancouver Island as well, and in British Columbia. It hasn't had that sort of explosion of unregulated growth that caused some problems in some U.S. states, even though the industry continues to be largely unregulated. And really, when you're talking about medical cannabis dispensaries and people who produce for them, wholly unregulated, because the federal government's refused and continues to refuse to bring the industry into the fold, and instead prefers to leave it out in what is technically the criminal marketplace and under the full weight of cannabis prohibition. So it's a real honor to talk to everybody here tonight. If you're in this field, if this is your calling to help other people, either as a producer or distributor of medical cannabis, I salute you. It is not an easy path to walk at times, and it's become, unfortunately, even more difficult and even riskier very, very recently here in Canada with the imposition of mandatory minimum sentencing on certain designated drug offenses. So what I'm going to hope to do tonight is not bore you too much with a PowerPoint presentation, really a keynote presentation. And hopefully I'll go through the presentation. We'll impart some information that you may not already know, or in a format you may not have seen before. Try to get as much of that information into your hands as possible. And then I'll take some questions. We'll take questions from the audience. We'll bring a microphone out. There'll also be, this event's being live streamed right now at pot.tv. And so anybody out there in chat can ask a question, and hopefully we'll have an opportunity to answer as many of those as possible. I've sort of expected to go a couple of hours tonight. If you've got to go, please. And if people start coming in late, please just find a seat. There's still some seats here in the front row, about 8 or 9 different seats here in the front row. I'll try not to spill my water on you or anything. And we'll hopefully have an informative and occasionally maybe even interesting and fun evening. I should also say, we are on the second floor here. This is a very old building. It's not fully accessible, and so hopefully People who are physically unable to get up here to the second floor tonight are able to tune in to the live stream. And even if they're not able to tune into the live stream, this will be uploaded. It'll be available through cannabisculture.com or pot.tv. And so people, if they're interested, you can direct them to that at a later time, and they can view it hopefully in the comfort of their homes or wherever they're able to do so. If you end up needing to reach me for any reason, I've put my contact information, some of it up there. Hopefully you don't have to call me because most people that call me are having a bad day. Unfortunately, don't get those midnight calls very often of, hey, I just called to let you know everything was all right. Although Dana Larson was kind enough to text me at about 1 a.m. A couple of weeks ago after hearing me constantly complain, or at least voice that same sentiment, that he just wanted to say he appreciated me. And so that was kind of welcome from Dana. The topic, of course, mandatory minimums in your medical cannabis business. My focus is going to be tonight on dispensaries, people that dispense marijuana for medical purposes. There's quite a few of them in the city of Vancouver, in British Columbia and across Canada. There's probably more in British Columbia than anywhere else in Canada, and more in concentration here in Vancouver than in any other urban area in Canada, or any other non-urban area for that matter. So I think it's a timely discussion here. It's also focused on producers. I mean, after all, there wouldn't be medicine to dispense to critically and chronically ill Canadians if there weren't people willing to do the hard work of producing a quality medicine and take the risks associated with that, risks that have also gone up fairly dramatically as a result of the Conservative government's omnibus crime bill, and particularly the mandatory minimum sentences contained in that bill. Probably as a matter of full disclosure, I should say I do represent a number of medical cannabis dispensaries here in Vancouver and on Vancouver Island. I'm involved in a number of pieces of litigation. I'll talk a little bit more about some of those later in the presentation. I'm happy to talk to anyone that wants to about representation after this event, or if you contact me via email. But if you are represented by another lawyer, I can't speak to you without that lawyer's consent. So I just want to make sure that everybody understands the parameters that I'm sort of bound to work by my regulator. So there's really two components to where people run into law enforcement issues vis-a-vis medical cannabis. And that's on the distribution end, the dispensing end, the selling end, or in the words of the Controlled Drugs and Substances Act, trafficking and possession for the purpose of trafficking. That's what PPT is, possession for the purpose of trafficking. It's prohibited by Section 5 of the Controlled Drugs and Substances Act. The other primary section is production, prohibited by Section 7 of the Controlled Drugs and Substances Act. And the Controlled Drugs and Substances Act, just to give you a quick overview, it is criminal legislation. It's not the criminal code. The criminal code is a different set of rules. It's a different statute. But the CDSA, despite its name, is in fact, and has been ruled to be by the Supreme Court of Canada in pith and substance, criminal law. It is prosecuted in the same courts as criminal code offenses, but it's prosecuted by federal Crown that work directly for Public Prosecution Service of Canada, Department of Justice Canada, as opposed to Crown prosecutors, provincial Crown, who prosecute criminal code offenses in the same courts, but under the auspices not of the federal government, but of the provincial government. It's not a distinction with much importance if you find yourself at the other end of a prosecution, as so many people have in the past, and as probably, unfortunately, some in this room may in the future. But that's the system we're under. So trafficking and possession for the purpose of trafficking. It's probably pretty hard to see all this small type, small font. But this is the section of the CDSA, Controlled Drugs and Substances Act, that says at 5.1, no person shall traffic in a substance included in Schedule 1, 2, 3, or 4, or in any substance represented or held out to be such a substance. And at subsection 2, no person shall, for the purpose of trafficking, possess a substance included in Schedules 1, 2, 3, and 4. For our purposes, the emphasis is Schedule 2. Schedule 2 is where we find cannabis and all of its derivatives and all the different synthetic cannabinoids that may be able to be produced that are currently prohibited by the CDSA unless you conform with one of the regulatory exceptions. This used to be a relatively straightforward provision. But in November of this year, it all changed, and it all changed as a result of these mandatory minimum sentences, and those appear in the center section here, and I'll read them to you, but I've got sort of the English version of it on the next slide, if you will, because this is, heavy on the legalese. But it says, every person who contravenes subsection 1 or 2, in other words, the sections prohibiting trafficking or possession for the purpose, is if the subject matter of the offense is a substance included in Schedule 2, is guilty of an indictable offense and liable to imprisonment for life. So the maximum sentence for which you can be incarcerated for selling cannabis in this country, for medical purposes or otherwise, or possessing it for the purposes of selling it, is life imprisonment. Now, that's an awfully long time. It obviously is not a sentence that's regularly imposed here in Canada, but there are some consequences of life being the maximum that I'll get to in a little bit. That hasn't changed. It was like that before Harper put in his mandatory minimum sentencing. It's like that now. That wasn't part of the omnibus bill. What is part of the omnibus bill is the next section, which says, and, so you're liable to imprisonment for life as a maximum, and to a minimum punishment of imprisonment for a year if you commit the crime with a number of different aggravating factors that are listed underneath that, and we'll get to those in a minute. Or a minimum punishment of imprisonment for a term of 2 years if these other factors apply. And that's for cannabis. Those are the offenses for cannabis, Schedule 1 and 2. Schedule 1 would be the drugs that most people commonly think of as quote-unquote hard drugs. It's a misnomer, but it'll give you a sense of what Schedule 1 is, and Schedule 2 being cannabis. So what does that mean? It means if the amount is 3 kilograms or over. So there is a cutoff point at which the mandatory minimum sentencing does not apply. If you are convicted of, after a trial, after any defenses you may bring, if you are convicted of trafficking in cannabis in an amount less than 3 kilograms, so about 6.6 pounds, you do not fall under the mandatory sentencing provisions, and your maximum penalty is not life, it's 5 years in prison. So it's treated for cannabis as a much less serious offense if you're under 3 kilograms. That's an important distinction, obviously. And what happens if you're under the 5 kilograms, actually, the 3 kilograms, is that you don't fall into this mandatory minimum regime. Now, if you do, however, possess cannabis for the purpose of trafficking over 3 kilograms, and most dispensaries that I'm aware of are quite likely to possess more than 3 kilograms of cannabis if they have a large clientele, or most producers, even if they have just a few plants, may in fact be possessing more than 3 kilograms because of the way the whole plant, not just the dried cannabis that comes off the plant. You're liable to 1 year in jail as a mandatory sentence of imprisonment if organized crime is involved, if you use violence or threaten violence, or if you've been convicted in the past 10 years for a designated substance offense. Now, a designated substance offense is essentially any controlled drugs and substances offense other than simple possession. So if you've got a conviction for production in the past, if you got a conviction for trafficking or possession for the purpose of trafficking in the past, you automatically are going to fall into the 1 year mandatory minimum sentencing provision. You're liable to a mandatory sentence of 2 years in jail if you commit the offense in or near a school, in or near school grounds, in or near any public place usually frequented by persons under 18, in prisons, prions too, I suppose, in prisons or grounds, or if you use the services of somebody under 18. This provision was sold as a protecting youth provision, but of course the difficulty is there's some vague language. You know, what is a place usually frequented by persons under 18? I mean, just about anywhere, really. I've got 4 kids. you know, ages 2.5 up to 12, and you know, they go anywhere. They go everywhere. We take them everywhere. So this is a provision that has yet, to my knowledge, to be tested in court, but to me it screams out for a vagueness challenge, because what does that really mean? It can be so broad as to include just about anywhere. The others are probably a little less problematic. I mean, it's fairly clear if you're using the services of someone under 18. I'm not sure about involving persons under 18. I'm not sure how far that would go, but obviously if you're a medical cannabis dispensary and you have a clientele that includes persons under 18, even if their parents have consented to them being a member, even if they are licensed by the government of Canada to possess cannabis for medical purposes, when you sell cannabis to that individual, you are committing the offense of trafficking, and if they aggregate all the cannabis together to get you over the 3 kilogram limit, you may well be facing 2 years of jail time as a result of that activity. So it's, this is the new provision, and this is what presents such incredible risks to people that are in this business. Now, derivatives present a special case. And I mentioned earlier that for a producer charged with possession for the purpose of trafficking, they'll often weigh the whole plant and say, well, that plant weighed, you know, 7.5 kilograms. And you sort of look at it and go, but it's, you know, not even in flour. And it doesn't matter. It's cannabis marijuana. They put it on a scale, they weigh it, and they come up with a number. Now, derivatives, we see, this is from subsection 6 of that same bit, for the purposes of paragraph 3A1 and Schedule 7. So 3A1 is a reference to the mandatory minimum provisions we just went over. Schedule 7 is where the government put that 3 kilogram limit in, right? So it's the 3 kilogram limit. So for purposes of the mandatory minimums and for determining whether or not you're over the 3 kilogram limit, the amount of the substance means the entire amount of any mixture or substance or the whole of any plant that contains a detectable amount of the substance. Now, you know, you can detect an awfully small amount of cannabis in a substance, even, for example, a plant in the vegetative state of growth, certainly in the acid states, and certainly for derivative products like cookies or edibles or oils. I mean, you know, your batch of cookies, because they'll weigh everything, not just the 5 micrograms of cannabis that's in it or whatever the case may be. They'll weigh the whole cookie, chocolate chips and all of a sudden your batch of cookies that maybe you have 1 ounce or 2 or 3 or 4 ounces of cannabis in, certainly under 6.6 pounds, all of a sudden that's taken you over the 3 kilograms and you're looking at imposition of a mandatory minimum sentence. So, as I say in the slide, put another way, cookies are punished more severely, and I'd say much more severely than raw cannabis, because they weigh the whole cookie. Now again, to my knowledge, this has not been made the subject of a challenge to date in the courts, but again, I think it invites that kind of challenge, because I would say even the intent of the statute as expressed by Mr. Harper was to go over serious organized crime, right? You heard that over and over again when they were selling this legislation. Serious organized crime, serious organized crime, serious organized crime. You know, the cookie baker with, you know, a bunch of batter and chocolate chips and a little bit of cannabis, I don't think qualifies as serious organized crime. And I should back up actually to say, you know, this 1 year provision, we see organized crime up there and it sort of conjures up an image of organized crime, and you sort of think biker gangs or you know, very violent sort of organizations. Well, organized crime is really, when you look at the definition, I didn't put it in here, is really more than a couple of people working together in an organized way to break the law. And so any dispensary, as a technical matter, qualifies as an organized crime activity, and quite probably brings you into the 1 year in jail mandatory minimum sentence. So what's the other half of that sort of equation, the other piece that affects medical cannabis dispensaries? Because it's not just about the selling of the product, of course. Somebody's got to produce that product. Somebody's got to grow it in order for it to be sold to critically and chronically ill Canadians. Well, the production offense in Canada used to be actually punished significantly less seriously, at least as a matter of statute, than the trafficking offense or the possession for the purpose of trafficking offense. Prior to these changes, the maximum punishment for production in this country was 7 years. It's now 14 years, but it's still not life. It's still punished less severely, theoretically, than selling the cannabis is. So what do we see here? We see a more complicated scheme applied to production because they've categorized it into a series of steps based on the number of plants, the reason the plants are being grown, and then whether or not any aggravating factors are present. So if the subject is cannabis marijuana, you're guilty of an indictable offense. Your imprisonment is up to 14 years in prison as a maximum, up from 7. And the minimum that you could be exposed to under the new laws is 6 months in jail if you have 6 to 200 plants possessed for the purpose of trafficking. So anywhere between 6 and 200 for the purpose of trafficking, and they will have to prove in court that it was produced for the purpose of trafficking it, right? You're subject to this 6-month mandatory sentence. If they're not able to convict you of production for the purpose of trafficking, it doesn't apply. If you have under 6 plants, 1 through 5 plants, whether you're producing it for trafficking or not, this provision will not apply to you. Now, most producers, I would suspect, for medical cannabis dispensaries are not producing less than 5 plants of cannabis. Correct me if I'm wrong on that, but I suspect they'd have to be awfully big plants to meet the needs of even 1 or 2 patients at a dispensary. So, just as a matter of fact, I think that most of the people producing cannabis for dispensaries for medical purposes, even if it's not through a dispensary, even if it's just being sold to medical consumers, or you're producing it for an unlicensed person that needs it for medical purposes, you're going to fall into this provision. So the next step up from that is if there are 6 to 200 plants and there are these aggravating factors present. I'll get to those on the next slide, but they're very similar to what we just saw with the PPT and the trafficking model. There are a series of things that if they're present, it ramps up the penalties that are going to apply to the activity. So 9 months, 6 to 200 plants for the purpose of trafficking still, and the aggravating factors present. The next step up is 1 year, and this 1 year is if you have between 201 and 500 plants for any purpose. So if you're growing perhaps a sea of green under 2,000-watt bulbs in your basement, and you've grown 201 plants because you're doing sea of green and you're just growing really small plants in a tightly enclosed area, you are now subject to a 1-year mandatory minimum sentence for whatever purpose you produced it for, whether it was for your own purposes or whether it was for the purpose of trafficking. That then kicks up another 6 months for those same amount of plants, 201 to 500, if these same aggravating factors are present. Again, we'll go over those in a moment. You get 2 years for more than 500 plants, 501 plants. Again, for any purpose. It's assumed in the legislation, I think, that if you're producing over 501 plants, they are for the purpose of trafficking, and so you're going to get hit with a 2-year mandatory minimum sentence that then ramps up to 3 years in prison if it's 501 or more plants and these aggravating factors are present. So obviously, the aggravating factors are pretty important, and whether or not they're there is going to make a significant difference in what penalty you may or may not be facing if you're convicted. And those aggravating factors then are these 4 things. First, if you use real property that belongs to a third party in committing an offense. This is a big one. You rent the place where you produce marijuana, you're using real property that belongs to a third party. You lease the spot where your medical cannabis dispensary is operating, you're using property that belongs to a third party. Okay, so those factors are going to be present in most situations, I'd venture to say. And if they're not, if you actually do own the property that you're committing these offenses in, well then guess what? You're going to be subject either to federal or civil forfeiture of that real property because you used it in the instrumentalities of crime. You used it to commit a crime, even if you didn't pay for a single dime of the purchase or the mortgage with unlawful funds, even if you bought it with an inheritance, for example, and then you end up producing for a compassion club, for example, in the basement. They can seize the whole property. They can attempt to forfeit the whole property, either federally or civilly under a much lower standard. Now, forfeiture is not the gist of the talk tonight. It's mandatory sentencing. Forfeiture is a process that takes place outside the sentencing process. But be aware that that's a live issue. And it's also a live issue for landlords, I should probably add. So that's number one, third-party property. Secondly, did the production constitute a potential security, health, or safety hazard to persons under 18 who were in the location or in the area? Well, this is going to be fact specific. You're going to have to know what the particular circumstances of the offense are. The Crown does have to prove these aggravating factors at a trial beyond a reasonable doubt in order for them to kick in. But if they're able to do that, then you're going to be subject to the aggravating factor, and essentially that's going to tack 6 months on, or potentially a year on, to whatever sentence you would otherwise have received under this legislation. Third, production constitutes potential public safety hazard in a residential area. So here's again another one with some loose language. Well, potential public safety hazard. I suspect in many jurisdictions, people think that producing cannabis is automatically going to be a potential public safety hazard. I mean, who hasn't heard the propaganda around, you know, dangerous molds or dangerous electrical conditions, or, oh my goodness, what are they doing with the water that comes out of the plants at the other end? Putting it in the garden as fertilizer? I don't know what people, you know, but my point is there's a lot of propaganda out there. And unfortunately, in my experience, judges are not immune to taking dangers associated with grow ops generally and applying them in specific cases without the benefit of actually having those things proven to them. Hopefully, that's not going to occur in the context of these mandatory minimum sentences. And, you know, lawyers out there and people that are fighting these cases out there are going to force the Crown to prove what is the public safety hazard that you say was being produced. Why is that actually happening? Was it actually happening in this particular production facility? And I should probably pause to say, well, the last one is traps and booby traps. Okay, so if you're placing booby traps or you're allowing booby traps to be placed around your production area that might cause death or bodily harm, well, then you're going to be qualified as an aggravating factor. I can't say, I can't quibble too much with that. Shouldn't be placing booby traps. Not a good idea. Let me point out that production doesn't just mean growing cannabis and being a cannabis cultivator, for example. Production may well also include, if you have, as some dispensaries do, a bakery attached to your dispensary where you're producing edibles. That could very well be charged under the offense of production, not just possession or possession for or trafficking or possession for the purpose of trafficking. You could be charged with a production offense for producing those substances, and therefore you may fall into some of these production-based mandatory sentences, although it's a little unclear there because they're all linked to plants. And if you don't have any plants, how can you fall into this scheme? But production certainly does include the production of derivative products. There's another ancillary effect as a result of these changes. So there's a couple of direct effects. We've talked about directly what are the mandatory sentences that are now being imposed, or that now people in this industry are subject to being imposed on. There's an ancillary effect that arises when you get to sentencing. Now, in sentencing, you can obtain what's called a discharge. A discharge is a finding of guilt, but no entry of a criminal conviction, and the matter is either discharged absolutely, which happens as of the day of sentence, or you can obtain a conditional discharge, which typically requires you to go through a period of probation the successful completion of which allows the conviction to be discharged. That means you don't have a criminal conviction. You've been found guilty, but you could honestly say, I wasn't convicted of that offense because it was discharged. Now, judges have to, under the criminal code, which governs sentencing, think about whether or not you're entitled to a discharge. Now, in some cases, lawyers won't even make the argument because it's clear you're not going to succeed. But if you make the argument, judges are supposed to think about it. Now, this is 730 of the Criminal Code of Canada. So this is a sentencing provision. It says when an accused, other than an organization, pleads guilty to or is found guilty of an offense other than an offense for which a minimum punishment is prescribed by law, or an offense punishable by imprisonment for 14 years or for life, the court can, if it's in the best interest of the accused and not contrary to the public interest, instead of convicting the accused, impose a discharge. It used to be that I could obtain discharges, I wouldn't say regularly, but often for people that were charged with distributing marijuana for medical purposes or producing marijuana for bona fide medical purposes. There's a long line of case law that stands for the proposition that in British Columbia, a discharge is an appropriate sentence for people working at medical cannabis dispensaries. One of the cases I use very regularly is a case called R.V. Small, which is a BC Court of Appeal decision, in fact, reversing a term of imprisonment and imposing a discharge on Mr. Small for producing for the British Columbia Compassion Club Society. Another case that I've used with some frequency because it's much more recent is a sentencing decision in R.V. Barron, which is a case of producing 1,000 plants for the Vancouver Island Compassion Society. And the judge, the sentencing judge in that case, actually said it was the clearest case for a discharge, and she discharged Mr. Barron absolutely on the day we made the arguments. The clearest case for discharge she'd ever seen in her career as a judge, a career that ended just after our case, and at least in the BC Supreme Court. And so it was a long career. So it used to be that if you were convicted of PPT under 3 kilos, right, because remember that maximum was 5 years, or production, because that maximum was 7 years, and there were no mandatory minimums in place, used to be I could argue for a discharge. Can't do that anymore. Discharges are not available any longer because PPT and trafficking is punishable by a maximum of life if it's over 3 kilos. You can't get a discharge. And production is now punishable by imprisonment for 14 years as a maximum. And so for production, for any production, for producing one cannabis plant for your own purposes, you are no longer eligible for a discharge, not because of the mandatory minimums, because they wouldn't apply in that particular fact pattern, but because the maximum is 14 years, and therefore you are not discharge eligible. That's a very, very significant change that I think did not receive enough attention in our advocacy before this legislation was passed, because that's something that quite clearly is going to impact people who are maybe growing 1 or 2 or 3 plants for their own personal consumption, medical or otherwise, who ordinarily, at least in my opinion, ought to have received a discharge with, with no other aggravating factors. They can't get it anymore. And for others now, for any of these offenses for which mandatory sentences are applicable, well, you can't get a discharge anymore. That's off the table. You can't even argue for it. It'd be pointless to do so because the legislation says the judge can't impose it. So we talked about that. Trafficking in PPT, over 3 kilograms, life in prison, not discharge eligible. Same thing for production. I have a little bar making circular things, so that's telling me that my devices are speaking, but they're speaking slowly to each other. But the next slide essentially says production. It's the same deal. Because production's now 14 years, you don't get a discharge. Oh. I think we're back. Yep. So even a single cannabis plant for personal use, no longer discharge eligible. The other effect is on what are called conditional sentence orders. It's another available sentence under the criminal code. A CSO is what it's often referred to. And essentially, it's house arrest. It's a period of custody served in the community. So it's meant to be a jail sentence that you serve in the community rather than actually in jail. That used to be a pretty common sentence, particularly for cannabis producers or cannabis sellers, even for non-medical purposes. On a first offense type scenario, the Crown almost invariably asks for jail and often some, in my view, absurdly long period of time in jail for minor cannabis sales offenses. And I'd go in and argue for something significantly less, and very often the judge would land at CSO and say, okay, well, a period of house arrest. You have a curfew for 6 months, curfew expands a little for the next 6 months, and for a year you're serving this custody in the community. Very, very common sentence. One that you would reasonably anticipate being able to argue for under the old scheme and have some probability of success, particularly if you're in the medical cannabis area, even if there's some production that's not necessarily completely for medical purposes. Well, CSO no more. 742(1) of the criminal code says if you're convicted of an offense and the sentence of imprisonment is less than 2 years, the court's entitled to consider a CSO, a house arrest provision. So it's already got to be under 2 years. Now, there are some restrictions on whether or not the court can do so. And what 742(1) says is, first, the court's got to be satisfied that being in the community is not going to pose a risk to the public. Well, that makes sense, of course. It's not going to be contrary to the fundamental purposes and principles of sentencing set out in a different section of the code. But here we see at B, and I've bold-faced it, the offense has to not be an offense punishable by a minimum term of imprisonment. So if you are subject to mandatory minimum sentencing under these new changes, you can't argue for a CSO. A CSO is not going to be an appropriate sentence in those circumstances. And additionally, if the maximum term is 14 years or life, you can't argue for a CSO. So we've now gotten to the point where if you are possessing cannabis for the purpose of trafficking to your clients of your dispensary, for example, if you're producing cannabis for your dispensary, you have mandatory minimum sentencing legislation that applies to you, to your employees, to your producers, and you have lost the ability on the other side of the argument to argue for lenient sentences, for discharges, or for what would be, what I don't think is a lenient sentence, but certainly would be considered by some to be a lenient sentence of house arrest as opposed to a term of actual imprisonment. So it's the ripple effect, really, from the mandatory sentencing regime and the change in the maximum punishment for production that's created this scenario. Are there any outs? I mean, is there a place that you can avoid these kinds of consequences for medical cannabis distribution or production? Well, there's a notice provision in the CDSA. The court is not required to impose a minimum sentence unless it is satisfied that the offender, the accused person, before entering a plea, so before you've pled guilty or not guilty, and that occurs quite early in the process, was notified of the possible imposition of a minimum punishment for the offense and of the Attorney General's intention to prove any factors in relation to the offense that would lead to the imposition of a minimum punishment. So break that down from the gobbledygook into sort of straight terms. If the Crown doesn't give you notice that they're seeking the mandatory sentence and why they're seeking it, then the judge doesn't have to impose the mandatory sentence. So it is an out, and it's an out which transfers a tremendous amount of discretion into the hands of federal Crown and out of the hands of judges, right? Because we've seen on the one hand, judges have lost the discretion under this regime to give you no jail time, to give you a discharge, to give you house arrest, to give you a sentence other than the mandatory minimum sentence or below the mandatory. All that discretion is gone, but we've sprung into life some discretion on the hands of federal Crown if they fail to give the notice, if they choose not to give the notice, if the notice is deficient in some way, if the notice doesn't include the factors that they needed to prove, for example, that it was a rented property, one of the aggravating factors, or for example, that the production of 205 plants was for the purpose of trafficking, then the court has an out. Now, it says not required to. It doesn't say can't. And of course, a judge could still sentence you to jail because jail remains within the range of acceptable punishments from 0 to 14 years for production or from 0 to life for PPT or trafficking. But this is the source of some hope, at least I have some hope, that in appropriate cases, you can approach a Crown and you can say, look, is it really in the interests of justice? Is this really what this legislation was meant to target? Or can we forego the notice? Can you decline to give the notice to the accused person? And therefore, the mandatory sentences at the back end of the process aren't going to be automatically triggered. More outs in the CDSA, and this is going to be interesting to see how it plays this one out for particularly producers and sellers of cannabis. But if a court, it says here at 4, sentencing a person convicted of an offense under this part can delay sentencing. So the court can say, okay, well, I'm sentencing you for running your medical cannabis dispensary and possessing for the purpose of trafficking 10 kilograms of cannabis and 22.3 kilograms of baked goods and cookies and massage oil. I'm going to sentence you for that, but first I'm going to delay the sentencing to enable you, medical cannabis provider, to participate in a drug treatment court program or to attend a treatment program under subsection 722 of the Criminal Code. So if you go to drug treatment, if the court's willing to delay sentencing and send you to drug treatment instead, then we see at 5, if you successfully complete that drug treatment program, the court is no longer required to impose the minimum sentence on you for the offense for which you were convicted. Query whether or not people who have absolute, I mean, there are people that work at dispensaries that don't use cannabis at all. So query whether or not that individual is going to be sent to drug treatment to get out of the imposition of the minimum sentence. Certainly, I mean, if that's offered, it's an option that you should discuss and think about quite hard with your counsel and see if it makes sense for you or your circumstances. But it's sort of a little strange, isn't it? But at least there's an out there that can be taken advantage of to try to blunt some of the harshest impacts of this new sentencing regime. Can you fight back? I mean, that's one of the things I try to do, is fight back against the burdens that are imposed by the federal government on medical cannabis providers, medical cannabis producers, and frankly non-medical cannabis providers, producers, and possessors as well, is can we fight back against these really draconian sentencing provisions? Well, there's 2 provisions of the Charter that come into play in that pushback, and it's Section 7 of the Charter, which guarantees that everyone in this country has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Section 7 of the Charter is the area that has spawned the most litigation in the field of medical cannabis. It is the basis for the seminal decisions in this area, the Parker decision in Ontario, which really is the wellspring, or one of the wellsprings from which the right to have medical cannabis as a critically and chronically ill Canadian comes from. Hitzig in the Ontario Court of Appeal, Barron in the BC Supreme Court, the recent Smith decision on edibles in the BC Supreme Court, Svetkopoulos in the Federal Court Trial Division in the Federal Court of Appeal. These are all decisions founded on Section 7 of the Charter and really brought to protect the patient's rights. What we haven't seen a lot of is Section 7 arguments made directly on the behalf of the producer or the distributor, and an argument that that person's liberty should not be taken away in these circumstances, because taking away a person's liberty for growing a healing plant that makes other people feel better is not something that I believe should be possible in Canada or anywhere in the world. And Section 7 of the Charter, in my view, if it protects principles of fundamental justice, ought to protect the principle that helping people and not hurting them shouldn't land you in jail for 2 or 3 years of your life. And Section 12 of the Charter is the other principal avenue I think that these things will be challenged under. Section 12 of the Charter prohibits cruel and unusual treatment or punishment. And the test there is essentially, would the imposition of the sentence in the circumstances at play shock the conscience of a Canadian reasonably informed of all the facts and circumstances? There has been some litigation about Section 12 and mandatory sentencing. There's been a case on the mandatory firearms sentencing out of Ontario. A judge threw out the mandatory sentencing provisions as violating Section 12. The Quebec Bar Association, the association that represents Quebec criminal lawyers, has filed an action in Quebec Superior Court about the drug mandatory sentencing provisions, seeking a declaration, a proactive declaration from the court that they violate Section 12 of the Charter. And I myself have a couple of cases in which it's likely to become a live issue in the near future. Now, these mandatory laws only apply to people charged after the date the laws came into effect. So if you were charged before, I think it was the 6th of November, 2012, you're not subject to mandatory sentencing. It doesn't apply to you. But of course, people have been charged since then, and undoubtedly this is going to start winding its way up in the courts right across the country, not just in British Columbia or Quebec. So one of the things that lawyers, I think, will be arguing is that we have a long history in Canada in the criminal code of what is sentencing for? What's the point of sentencing people who violate the criminal law? And how does that fit into Section 12, prohibiting cruel and unusual punishment? Well, the principles of sentencing, fundamental principle of sentencing, fundamental purpose of sentencing is right there. It is to contribute, along with crime prevention initiatives, to respect for the law and the maintenance of a just, peaceful, and safe society by imposing just sanctions that have one or more of the following objectives. First, denouncing unlawful conduct. Don't do that, it's illegal. Second, deterring the offender, specific deterrence of the offender. You should not break that law again. Or other persons, general deterrence, people out in society. You shouldn't commit this crime because we're sentencing people for committing this crime. To separate offenders from society where necessary. To assist in rehabilitating offenders. To provide reparations for harm done to victims or to the community, and to promote a sense of responsibility and acknowledgement of the harm done to victims and to the community. So when I'm arguing sentencing in a medical cannabis case, I say, look, you don't need to denounce unlawful conduct here, Judge. Most Canadians believe that people should have access to cannabis for medical purposes. Most Canadians don't believe it should be criminal for people to produce and distribute cannabis for medical purposes. You don't need to denounce this unlawful conduct. You don't need to deter this offender. Although some offenders need perhaps more deterrence than others. But certainly, listen, as a scientific matter, and I've never made this argument in front of a judge yet, but as a scientific matter, I'm not sure that deterrence is a concept that holds much water. You know, we see even in the most draconian regimes where people are executed for possessing drugs, people still do it. People still will grow it if you're going to get 10 years, 20 years. In the States, you get life in prison for growing some marijuana. People are still doing it. So I'm not sure the concept of deterrence holds much reality when it comes to what actually happens on the ground. But you mount an argument that it's not necessary to deter others from committing offenses. Medical cannabis producers and distributors don't need to be separated from society. They don't need to be rehabilitated. There's no victims. There's no reparations needed. There's no harm to the community. And quite frankly, people in this industry are some of the most responsible people that I know, and they're some of the most community aware and active people that I know. And so I say none of these objectives, other than perhaps denunciation of unlawful conduct, because it is technically illegal, really applies in the case of medical cannabis producers or distributors. And so how can a mandatory jail term that doesn't meet any of these fundamental purposes, it's not contributing to the respect for the law, it doesn't help maintain a just, peaceful, and safe society, it's not a just sanction, it doesn't achieve these objectives, how is that not cruel and unusual punishment if it doesn't even do what sentencing is supposed to do? There are other basic principles of sentencing that I say the mandatory minimum provisions offend. And this is also for 718 of the Criminal Code. Sentences are supposed to be proportionate to the gravity of the offense and the degree of responsibility of the offender. Right? So the more serious the crime, the harsher you're supposed to be punished. It's a proportional analysis. Well, when you're talking about producing and distributing cannabis for medical purposes to sick people who are, healing and being made to feel better from it, I'd say jail is disproportionate, grossly disproportionate to the gravity of the offense. Courts also have to take into account certain principles that A, sentences should be increased with aggravating factors or reduced with mitigating factors. I say the reason, your intention, why you're doing it is a mitigating factor because you're doing it to help better people's lives. Further, we see down at 5B, sentences should be similar to sentences imposed on similar offenders for similar offenses in similar circumstances. The idea is that person A, who did sort of the exact same thing as person B, person A ought not hang while person B gets a slap on the wrist. You're supposed to have some consistency in sentencing so that people know what to expect and so that there's a sense of fairness promoted when people think about the criminal justice system. So how can it be that the day before these mandatory sentences came into effect, it was, I would say, if not common, certainly reasonably possible for somebody that works at a dispensary, for somebody that grows marijuana for medical purposes. I went into court and I would argue for a discharge for those people, not even a criminal record. And I got it. And lots of people got it. How can that same offense on the 7th of November now be a 3-year jailable offense or a 2-year jailable offense without offending this basic principle that it ought to have some consistency? D says an offender should not be deprived of liberty, i.e. jailed, if less restrictive sanctions may be appropriate in the circumstances. Again, how do we not offend this principle by locking up people for growing this plant or for selling this plant that helps people? And again, the final basic principle is that available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. So if judges are being directed on the one hand to consider everything other than imprisonment before you jail somebody, and they should, jail doesn't work very well. Jail's a pretty bad way of doing criminal justice, quite frankly. So the judge ought to think about this. But on the one hand, you're told to think about it. On the other hand, well, now that you've thought about it, you can't do it because you got to lock them up, because that's what the CDSA now says. So I say all of these basic principles, this is how we've been doing sentencing for a long time in Canada, are offended by this drug war and by these mandatory jail sentences that are going to start being imposed on people. There's a bit of case law out there. I don't want to turn this into sort of an extended discussion of the case law. If you're interested in that, there'll be several trials in the next year that you're happy to come and attend and see me sort of go on at length wearing more formal attire on what these cases actually mean. But just to highlight a couple of notable ones. Barron, which I mentioned earlier, it's along with Smith, probably the two seminal decisions on access to medical cannabis in British Columbia, both at the BC Supreme Court stage. RVO and Smith is on its way up to the BC Court of Appeal. That's a case involving edibles being produced for Cannabis Buyers Club of Canada. Mr. Barron was producing for the Vancouver Island Compassion Society. That case actually ended at the BC Supreme Court level because we won, and yet he was convicted, and then the Crown and we ultimately had to try to bypass the BC Court of Appeal, go straight to the Supreme Court of Canada. The Supreme Court of Canada didn't want to hear the case, and so that case ended at BCSC. Mr. Smith's case on its way to the BC Court of Appeal. I expect an argument this year. There's many, many, many provincial court decisions, which is really a testament to, I think, the bravery of the people that are in this industry, especially in the early days, that were fighting so hard inside and outside of court to gain some legitimacy and some recognition. Ted Smith, couple of cases, Philippe Lucas, absolute discharge for operating dispensary. Mr. Small, one of the early production cases, went to the BC Court of Appeal, 2 cases actually, and so many more. I couldn't, you know, we'd be another hour if I sat up here and sort of named them all and gave you chapter and verse on them all. But there is case law out there, and it's case law that, in my opinion, supports access to medical cannabis, and it supports arguments that sentencing people to these mandatory sentences is violative of really the tradition of both substantive charter law and sentencing law in this province. There are a number of ongoing challenges that I'm currently working on that will affect things in this area, not necessarily sentencing, but potentially sentencing because of demonstrating that the current scheme or the new scheme may or may not be invalid. R.V. Smith, I talked about. R.V. Kane, it's a Compassion Club case out of Langley involving a charter challenge. We've got a hearing this year. R.V. Johnston and Steplock, that was the Metrotown dispensary case. That's pending in BC Supreme Court. There'll be a charter hearing this year. R.V. Jacob, BC Provincial Court hearing, charter hearing this year. Again, challenging the validity of the scheme. R.V. Cloquet from iMedicate. Mr. Jacob was North Island Compassion. Cloquet, iMedicate here in Vancouver. Also in BC Provincial Court with a preliminary inquiry coming this year. And, you know, the future is uncertain. That's a lot of litigation, I can tell you. There's a lot of sleepless nights involved in those pieces of litigation, not just for counsel, but obviously for the people involved. Really, it falls most heavily, I think, on their shoulders. And hopefully a lot of progress to be made in the courts, because right now we're not making progress in Parliament. Unfortunately, we're going in the wrong direction. And so I'm hopeful that we can continue to push the envelope in the court system, at least, begin to carve out a niche and a safe zone so that people can continue to do the good work that's benefited so many Canadians. More ongoing challenges. I mentioned the Quebec Criminal Bar. They've filed suit seeking a declaration the mandatory sentences are unconstitutional. That's, you know, a heavy-duty organization. They've got resources. They've got a lot of bright people. It makes me wish I still spoke French so that I could actually understand and read the pleadings. But that's, you know, a ray of sunshine in an otherwise dark environment. And as I mentioned, I'm awaiting some instructions on cases for which people have been charged for medical cannabis production since November 6th. It's possible that they'll be facing mandatory sentencing as a result. And if they are, and I'm instructed to do so, we'll be bringing charter challenges to try to protect those people from really an unjust regime and some unjust sentences. So that's the presentation part of the evening. Thank you for your attention. I really do appreciate it. If you need to reach me, there's a whole bunch of ways to do so up on the screen. I have not enough business cards to give everyone, but I'll give as many out as I possibly can if you're interested. Thank you so much for your attention. Thank you. That means a lot to me. It's hopefully it was not too dry. Hopefully it was informative. It's a grim topic. I mean, I know that. It's a terrible path that Canada's going down. I saw it happen in the United States when I practiced criminal law there. Practiced criminal law in the state of Michigan, which at the time I was there had the harshest mandatory minimum sentences in all of the United States. I will never forget, it's not medical cannabis, but I'll never forget a case we represented. A young man, resident of California, was alleged to be shipping 4 or 5 kilo bricks of cocaine all around the country by UPS. Now, one of thousands, tens of thousands of people doing that every day in the United States. His sister alleged to have been the mule that delivered the cocaine to the UPS store in California. It was destined for some recipients in Michigan. They set up a controlled buy in Michigan. They extradited the 2 accused persons from California to Michigan because in California they were looking at 5 years. In Michigan they're looking at 20. And in Michigan, when you get sentenced to 20, you do the 20, and it's mandatory, and there's no getting out. There wasn't enough evidence against our client. You know, we sat in the courtroom for 3 days, And every day they'd trot out the 5-kilo bag of cocaine, they'd slap it down on the table. So they sat there in front of the judge, you know, looking all ominous and scary and impressive. But you know, every lunch, everybody would leave the courtroom. The security would leave the courtroom, the clerks would leave, the judge would leave, and the other defense lawyer and I would be standing there with this giant 5-kilo bag of cocaine. And you know, it's something that they were going to jail people. You know, we're going to put human beings in cages. It's so dangerous. And we're just leaving it on a table in the courtroom. It stunned me. Our client, there wasn't enough evidence to convict him. We made at the end of the Crown's case, we made a motion for a directed verdict of acquittal. We got it. Our client, alleged to be the mastermind, gone, free. Sister, not so lucky. You know, they tried to lean on her, to lean on him, and you know, his comment was, look, we get this from the mafia, Mexican mafia. They know where my mother lives, they know where my sisters live. Nobody's talking about anything. And the sister gave the same instructions to her lawyer. I'm not saying a word. And she's still in jail today. 20 years was her sentence. So, you know, this is evil, what we're doing to our country and the people. They're learning in the United States how evil it is, how destructive it is. And they're changing. And we're changing here too, but we're changing for the worse. And we're going down the same path. And it's not healthy for our criminal justice system, not healthy for our people, and particularly in the area of medical cannabis. It's not healthy for the hundreds of thousands of Canadians who depend on this plant for a better quality of life. So, very serious topic.